a very long, lengthy
Don't abandon us.
introduction.
You see, she's in full African regalia, just as Mama Africa should be. Thank you.
Always, Laura, always. Thank you so much for the introduction, and good morning, everyone. I have had the honor and the chance to speak with some of you this morning earlier at breakfast. I am delighted to be here today. I wish to, before starting with my panel, allow me 2 minutes to acknowledge and congratulate ICC Kenya for the wonderful job that was done in not only designing but then organizing this conference, making it really a flagship event in the current context and making sure that everyone can meet while staying safe. I also want to acknowledge our supporters, starting with KEPSA, with also the Kenyan branch of CRB, and of course I would not fail to mention our sponsors, without whom this event would not be possible today. So thank you very much to all of them, the Dr. Mutubwa law firm, Anjewala and Kana, also CDH and Triple OK. So thank you very much to all of them. I'm delighted to also now welcome our panelists for this new panel. We're going to be discussing the realities of ADR in the COVID-19 climate and virtual ADR. And our panel is, I think, one of the manifestations of this reality. Sebastian and myself were initially supposed to be in Nairobi, and due to COVID-related issues, we had to stay here in Paris, whilst Laura Lusigi and James Kihara are both over there in Nairobi. So I think we're the perfect panel to tell you a little bit about that. So our panelist, Laura Lusigi, I'll start with her, is a qualified advocate of the High Court of Kenya. She has over 5 years of experience of advising clients on alternative dispute resolution mechanism. Laura has advised and represented clients engaging in international arbitration in relation to disputes under the auspices of a number of institutions, LCIA, DIFC, LCIA, Antitrol, Ad Hoc, FOSA, etc. Her experience covers a wide range of industrial sectors, trade, hospitality, telecommunications, for example. And also Laura has also facilitated various trainings on alternative dispute resolution, including training members of KEPSA, also training members of the Kenyan Ethics and Anti-Corruption Commission on the use of alternative dispute resolution to resolve their disputes. Our next panelist is today James Kihara. I believe you all know him, but I'm really delighted to introduce him today. So he's the managing partner of the law firm Kihara and Wine Advocates. He's a chartered arbitrator, accredited mediator, adjudicator, and a certified public-private partnership specialist, as well as a certified governance auditor. So James Kihara has worked in the Office of the Attorney General as a corporation secretary in several state agencies as well. James is a former chairman of the Chartered Institute of Arbitrators, the Kenyan branch, that is, and he's also the immediate former chairman of the Public-Private Partnership Petition Committee. James sits in the board of several entities, including the Nairobi Center for International Arbitration. We were just talking about NCIA. And this year, James was recognized by the Legal 500 in its arbitration power list for 2021. Congratulations, James. The third panelist we'll hear about today is my colleague, my very dear colleague, Sébastien Pépin. Sébastien is a counsel with the ICC International Court of Arbitration. He oversees the management of cases in what we call the case management team, the common law case management team. Prior to joining the ICC, actually, Sébastien had interned in several international arbitration teams in top international law firms, and he's a member of the New York Bar and also holds an LLM degree from Vanderbilt University. Sébastien took a dual degree from King's College and Université Paris 1, Panthéon-Sorbonne, and he is educated in both English and French law. He's fluent in English, French, Spanish, and German. So you now have the full details of all of your panelists for this conversation, and I'm going to open the discussion by inviting Laura to tell us a little bit about her perspective as counsel of parties engaged in the ADR, and that is arbitration as well as mediation, conciliation sometimes, in this context that we all have been going through in the past almost 2 years since the COVID-19 pandemic started, and the virtual working context it has entailed for most of us here. I would like you, Laura, to comment more specifically on the concrete changes that this has brought to your activity in the first instance, and maybe one of our co-panelists can then jump in with some comments. Laura, you have the floor.
Thank you, Diawana. Good afternoon, everybody. I'm glad to be here. So just before I start speaking on the realities of AD in the COVID-19, I just want to say that I will focus mainly on international arbitration, mainly because of time constraints, and perhaps towards the end, we can talk about the other forms of ADR. So the first point that I'd like to note is that virtual ADR is not really a new concept in the ADR field. Previously, even before the pandemic, there were certain aspects of international arbitration that had to be done virtually. For example, case management conferences, most of these have been conducted virtually because, you know, it takes place in such a short period of time, and it did not make any sense for all the parties to convene together in one room. We've also had experience or situations where certain parties were witnesses were cross-examined virtually because of one reason or the other. Then national arbitration I was involved in that was seated in Dubai, but one of the witnesses was cross-examined virtually. He was in India because of health-related issues. Also in internal arbitrations, documents are mainly exchanged electronically. So with the pandemic, this is not something that has been that has not been experienced before. Where we have seen a shift at the onset of the pandemic is in hearings, because most of the times in international arbitrations, hearings are conducted physically, where parties all convene in one room, and you have the claimants, the defendants, and the tribunal in the same room. Now, with the pandemic, with the travel restrictions, social distancing, ban on gatherings, it rendered physical hearings almost impossible. And parties and the tribunals have been faced with the decision on whether to postpone hearings or to conduct the hearings virtually. Many of us who are practitioners know that arbitrations, rather than tribunal, conduct hearings in a manner not to cause emic to lapse in order to conduct a hearing, would actually be delaying the. We have seen arbitrators leaning towards conducting virtual hearings. One of the challenges that we have had with this is, the resistance of conducting virtual hearings, both from the arbitrators, the legal practitioners, and even the clients. I recall a matter that I was involved in where, our client, may his soul rest in peace, was completely having a virtual hearing. He felt that the tribunal is not going to hear his case properly because, you know, they are hearing the lawyers through a screen. He also felt like he's not going to be able to tell the demeanor of the tribunal. You know, human interaction, you know, can tell a lot. So he felt like the tribunal is not going to, you know, he's not going to be able to tell how the tribunal is doing his case if we're doing it virtually. So as a practitioner, that is what challenges that one has to think about and address to work around the issues that your client may raise as a result of, you know, these virtual hearings. And I'm sure even when Dick's going to give us his perspective as an arbitrator on how virtual hearings were first, you know, how the tribunal felt about them when they heard about them. The other point that I want to talk about is, you know, as a legal practitioner, there are certain things that you'll have to think about as you go into a virtual hearing. The first, particularly for international arbitrations where you have, you know, parties in different parts of the world, you'll have to think about time zone. So there are instances where you're having witnesses who are in the United States, you're having a tribunal perhaps that is in London, you're having other witnesses or lawyers that are in China. So you have to work out how you're going to set up your virtual hearing so that, you know, it is conducted in a time that is convenient for all the parties. Another point that is of contention is, of course, the integrity of oral evidence that is given at the hearing. You know, sometimes parties worry about the integrity of cross-examination during virtual hearing because, you know, how do you know that someone is not standing in front of the witness and, you know, holding up placards telling him what to answer during cross-examination, and one solution for this that has been proposed is that, you know, you should have cameras that are showing a 360-degree view of the witness, so that at least you know that the witness is by themselves in the hearing room. Another factor that one would also have to take into account is cybersecurity and the principle of confidentiality in arbitration proceedings. You want to make sure that the platform that you're using is secure so that there's no hacking into the hearing. And perhaps another point that I will talk about, I know we are pressed for time, so one point I'll talk about before I leave the floor for my fellow panelists is documents. You know, during the pandemic, we have had cases where parties and even the tribunal don't want to receive hard copy bundles of documents because of, you know, the spread of the virus. So you have to think about e-bundling systems. You have to think about having platforms that would allow you to see the documents being referred to the hearing, and not just you, but everybody else in the hearing room. So those are some of the factors that as practitioners we've had to think about as we go into virtual hearings for international arbitration. So Diawana, I'm going to stop there for now and give room for my fellow panelists to also comment on the topic.
Thank you very much, Laura, for these different aspects of your activities and the impact of COVID-19 in that context. I would like to invite maybe Sébastien to comment on one thing that you've raised. Laura, you were talking about the fact that most of the activity now is being done remotely when it was previously in a physical context. Sébastien, maybe in a very concrete manner, can you tell us what it entailed for an institution like the ICC to switch its activity to a fully virtual context, maybe overnight, when the first restrictions were implemented at the headquarters in Paris?
Yes, absolutely. Thank you very much, Diamana, and it's a pleasure to be here among you all. We're obviously regret the fact that we cannot be there in person, but happy to see you all on the screen. It really did happen overnight, really, for us. It was from a Friday to a Monday, as much as the technology was there, we weren't utilizing it yet. And so I think it had to be fast-tracked, and there was some very immediate changes that were needed. But ultimately, it ended up, and the resounding feedback is that it's a positive experience. It is catapulted through and sort of fast-tracked, as I said, processes that should have probably been implemented a while ago. And so we see it in some ways as a possibility to enact positive change. Obviously, the ICC is a global community, and in particular the court sessions. We have court members from all around the world, and the fact of now having, or since COVID, having online court sessions, purely online, means that we have increased participation in our court sessions. It means that there is a getting together of minds which is greater in such a rich environment of practitioners. So we've seen the international community sort of getting closer in some ways, or at least our network. We've seen possibilities for fostering greater connections and collaborations with our partners all over the world. So in some ways, this has been the stepping stone and really the sort of the push that we needed to enact certain changes to render our global community an even closer community.
Thank you very much, Sebastian, for sharing that experience. And I can comment on the fact that, for example, for our now 27 African court members, the majority of whom are based on the African continent, it did allow a huge jump in the number of African court members participating on a regular basis into the court sessions. We do have vice presidents such as Ndanga Kamau in the room who were already very active, either in person or via a virtual video link participation. But this new context has definitely acted as a sort of a particles accelerator when it comes to increasing the participation of our court members from every corner of the globe into the sessions. Before I give the floor to James Kihara for him to share with us his perspective on this as an arbitrator, I would like to address to Laura one very short question. You were mentioning the fact that some of your clients were a bit skeptical as to would this new context allow to convey properly their position to a tribunal, and would their points come across the way they wish in that context, coming from their counsel towards an arbitrator or an arbitral tribunal. I'm curious, and of course, if you don't want to share any trade secret here, keep them to yourself. But Laura, what techniques did you, for example, develop to respond to this kind of challenges or concerns of some of the clients?
Thank you, Diawana. We had to have a conversation with the client, explain to them that apart from the fact that we are not, in a physical room with the tribunal or the other parties, the tribunal is listening to their case, and they will also have the opportunity to, watch the tribunal, watch their demeanor through a screen. It's not physical, of course, not what the client was used to, but, he will be able to look at the tribunal, he'll be able to hear them, and he'll be able, to perhaps draw any conclusions that he felt he could draw in a physical hearing. Well, I do understand the importance of human connection and human interaction and the reading of body language, and that was the concern for the client. But what we did was, assure him that as much as we are not in the same room with the tribunal and the other parties, the screens are showing what's happening real time with the tribunal. And so he'll be able to, watch them through the screen, and he should feel satisfied his case would be heard as well as it would have if we were in a physical hearing.
Yes, great, thank you. And I assume also the fact probably that in any event, both sides are on an equal footing in this context must have also been reassurance. It's not like one party is physically in front of the tribunal whilst the other is pleading its case through the screen. Everyone is in the same situation in that case. Moving now to James Kihara, we would love to hear your perspective as an arbitrator here, I'm asking you, on the changes that came about with this new normal, as sometimes we hear it called, brought about by the COVID-19 context, and in particular, what would you say is the difference for you between conducting an arbitration in person and the post-COVID-19 way of conducting an arbitration? What positive maybe experience, what difficulties have you encountered?
Thank you, Diawara, and I would wish to appreciate ICC Kenya for coming up with this meeting where we can share our experiences. Now, as an arbitrator locally here, probably maybe I may focus more on domestic arbitration because my sister here has talked at length about international arbitration. Domestic arbitration, when COVID hit, most of our proceedings more or less came to a standstill. Why do I say so? Laura says that a lot of proceedings, they were already doing them internationally, online. But locally here, what we were doing was that all meetings, the proceedings were being done probably at the Chartered Institute or some other venue. We had physical hearings. Now, there was really not much of virtual proceedings other than email communications, and there was a lot of paperwork crossing from arbitrator to the parties to the arbitrator, and so on and so forth. So when COVID struck, proceedings, there was a great effect on the proceedings, arbitration proceedings, because they more or less came to a halt. And you realize in most proceedings, there is always one party who will probably be dragging their feet. And that was an opportunity for that party to take advantage. And therefore, the proceedings were definitely going to be delayed. Now, another great effect of COVID to arbitral proceedings was, now the perennial adjournments that were being sought for one reason or another. This one is not available, and this one is unwell, or this one had this contact. And there's nothing really as an arbitrator you would do because, somebody says they had contact and cannot be able to participate in the proceedings. Then that, of course, took a great effect. So that brought the benefits of arbitral proceedings back behind, because now for proceedings that you hoped would take at least 1 year or less, now this was taking quite a long. Now, between March last year, April last year, and today, I would be happy to say that now we have gained traction. We have embraced virtual proceedings very much. Personally, I know virtual proceedings have saved a great deal of costs, because as I had said previously, you find you as the arbitrator, you have to drive to the venue. The parties also drive to the venue for even interlocutory proceedings like preliminary meetings or interlocutory applications. And we know how, like our city is here in Nairobi, where one party can leave their office hoping to get to the venue in time, and they are late. So again, you have to wait. And after the proceedings, you are all driving back. You can imagine the man hours spent on, time, the traveling, the cost, the fuel, and all that. Today, the beauty is you are able to save time, because 5 minutes ago, 10 minutes ago, you could be handling something else in your office, and then your meeting starts, for example, at 2 o'clock, you go online. However, virtual proceedings have also had their own challenges, because again, the technology is not standard for everybody. So you find that probably one person is having challenges. And, you'll not find litigators or, counsel to be honest all the time. So if somebody wants to get an adjournment and he really wants to get that adjournment, I know people have used technology to say that, that they are not able to conduct the proceedings properly because maybe their system is not working properly. Now, what option do you have as an arbitrator? That matter would have to be, adjourned or given another date. So there are people, of course, who are taking advantage of the system. But all in all, we have saved colossal amount of time and costs, and in particular, the speed within which you are able to hear your matter. Because again, I find that parties or their representatives are more flexible with time and dates. Before, somebody will tell you, this month I don't have time, my diary is full the next month. But right now you find it is easier for somebody to say, I have some opening next week or next week but one, and you're able to conduct your proceedings within a very short time. But right now, I think practitioners, that is advocates and the representatives of parties in arbitral proceedings and arbitrators, we are now all, we now probably can say now we are some experts in ICT. Some of us never used these virtual things before March, but right now we are able to conduct these proceedings. However, when it comes to what I've noted in contrast to international arbitration, when it comes to the actual hearing, you will find that here locally, advocates or parties will always prefer a physical hearing. So long as you're able to, distance yourself, but the bulk of the arbitration time is taken by the interlocutory proceedings. That takes colossal amounts of time, and that is what now has helped, because we are able to reduce that time, because the hearing is probably 1 or 2 days that you will be able to handle that. The other positive thing is about the flexibility. Parties now are more flexible. I have noted in particular, right now, counsel representing, particularly counsel representing parties in arbitration, they tend to opt for meetings at around 12, 1. There are some have even conducted at 2 or 3, because that frees them off the morning hours for other activities. Maybe they are participating in the court. So that flexibility, of course, has also helped a lot, because nobody would want to leave their offices at 3 o'clock to go to a meeting. But if there is a meeting that is happening at 3 o'clock, for example, an interlocutory meeting or an application or highlighting of submissions, that can be done at 2 o'clock or 3 o'clock. And of course, that has helped expedite proceedings. So those are some of the advantages and the positives that we have been able to get from this process. And of course, there are a couple of disadvantages I've talked about, but for now, I think we are back on track. Everything has gained traction, and I think we are good to go. Thank you.
Thank you so much. Thank you so much. Thank you, James, for sharing this very enthusiastic account of what, in a way, COVID-19 has improved in the processes of an arbitration. And here, I'd like to briefly invite Laura to simply actually comment on one thing you said while you were finishing your presentation. You mentioned that you think that most advocates and counsel of parties or parties themselves probably would prefer in-person hearings or in-person arbitrations generally with meetings being held in a physical manner. And I want to ask you, Laura, do you think that when we finally, and I hope we're getting there, get out of this pandemic, you and your clients will wish to go back to the way it was before?
My view is that I can see a future in virtual hearings, even post-pandemic. At the moment, it's something new, but you can see that it's something that's embraced, although slowly. We are seeing that international institutions for arbitrations are starting to incorporate virtual hearings in their rules, like the LCIA. We are seeing protocols being issued as guidance for how to conduct, hearings virtually. So that gives guidance to the practitioners and the tribunals. So my view is that we will see a shift. It may not happen immediately because people are used to the physical hearings and it will be difficult to, have an immediate switch. But in my view, I do see that it is the future because as much as it also attracts expenses, at the end of the day, my view is that it is much cheaper to host a virtual hearing as opposed to a physical hearing. And particularly if we're talking about international arbitrations where we see parties traveling, spending a lot of travel costs on flights and accommodation to attend a physical hearing. So I do see a future where we will be having virtual hearings, at least for international arbitrations. For domestic arbitrations and perhaps even mediations happening locally, I can see that perhaps there would be a case for holding them physically, because parties are in the same location. So that just means that they will be traveling to a location not very far away from them as compared to international arbitration having physical hearings at different countries. That's my personal view.
Yes, thank you, Laura. And indeed, when I was listening to you, I was reflecting on the words earlier this morning of, I think it was Professor Muiga, who was saying that in a way we've lost the original interest of arbitration in a sense by having made it too costly sometimes for parties. And it's true that the shock that the COVID-19 crisis has provoked in so many aspects of our activities might, in a way, allow us an opportunity to revisit these issues, of course, revisit the way we assist the businesses in resolving their dispute, and maybe revisit the cost that we associate with this dispute resolution mechanism by looking at reducing some of the hearing costs, looking at reducing the travel costs, obviously, and so on and so forth. So thank you so much for that, sharing that position. I would like now to give again the floor to Sébastien for a more maybe detailed account of, the changes from an institutional perspective brought about by the virtual context forced upon us with the COVID-19 crisis. And, Laura was telling us earlier how, in a way, by doing international arbitration, by nature, our work was already very much virtual. You might have a party, one party in Singapore, another one in Dubai, and have a tribunal seated, one member of tribunal seated in Nairobi, another one in Paris, another one in New York, and that would form an arbitral proceedings. And these different actors of the proceedings would exchange virtually with the ICC court and secretariat orchestrating these proceedings. So I want to ask you, Sébastien, what in concrete terms have been the actual changes in the way you conduct the proceedings at the ICC brought by this situation beyond already the exchanges you were having remotely with all of the participants in a given case?
Thank you very much, Diamana. Yes, I thought it'd be interesting to bring really the perspective from the institution and how it's changed our day-to-day management of cases. What we've seen is the major changes in cases since the COVID pandemic, and really on the eve of or just after the pandemic started, the ICC issued a guidance note on possible measures aimed at mitigating the effects of the COVID-19 pandemic. And it sets out several important changes to the way in which the Secretariat and the court functions. Most importantly, and maybe the change which has had the greatest impact in terms of our work, has been the electronic filing of requests for arbitrations and the electronic notifications of requests, as well as the electronic notification of awards. What we've seen is that nowadays, for a majority of cases, we are electronically notifying requests for arbitration, and we are receiving all correspondence and all submissions electronically. Tribunals are increasingly requesting that all submissions are only filed electronically also. And what we're starting to see, but it's still not a majority of cases, are electronic signatures on awards and awards being notified electronically. There is a slight difference, I would say, in how it's been welcomed by the common law world and the civil law world. There seems to be a greater hesitation from civil law lawyers, and this may be just because of the strictures of enforcement proceedings in civil law local courts. It could also be, on the flip side, the fact, a reflection of the fact that the common law jurisdictions have been more able to quickly transition to a virtual arbitration world. I know that I believe in Kenya now, filing by WhatsApp is accepted, and so we were very pleased to hear that, and it's a reflection of a changing world, and hopefully all lawyers will come up to speed, and all jurisdictions will come up to speed with that. So ultimately, that's been the major change in terms of our functioning at the Secretariat. What we've seen in the cases is the major change is a subject which has been touched upon by my fellow panelists, and that is the prevalence of virtual hearings. I don't have any specific statistics in that regard, but what I can discuss is my experience as a case manager at the Secretariat. And that was that at the start in April of last year, I saw most tribunals that were postponing evidentiary hearings, generally until the summer or sometimes sooner than that. When the extent of the pandemic started to become apparent and more inevitable in some ways, that's when we started to see tribunals be more forceful in their suggestion that should a hearing in person not be possible, that virtual hearings should be considered. And really by sort of autumn of last year, we started seeing a majority of hearings being held virtually, and that is something which has continued to this day. And I just wanted to touch upon a question that you asked Laura earlier on about how maybe we can envisage the future post-pandemic. And I think it's interesting to note that the Queen Mary University of London, within the context of their study, asked users what they would prefer once the COVID-19 related restrictions were lifted. And it appears that at least for procedural hearings, remote functioning will still be very much the preferred course of action. And for evidentiary hearings, there seems to be a divide. And I think that sort of echoes what has been said. Just over 40% prefer the return to in-person hearings. Similar figure of users preferred a mixture of in-person and virtual, and a bit less than 15% preferred purely virtual hearings. So I think this is also something which is changing with time. Generally, the feedback that we've received at the institution is positive in terms of how virtual hearings have gone. And so I think people are obviously opening themselves up to the benefits that James very eloquently portrayed of virtual hearings. And just to touch upon maybe some of the developments at the ICC, virtual hearings have always very much been a possibility. It's something of a misunderstanding maybe with the previous version of the rules, which has been clarified now since the inception of the 2021 rules, where it is in black and white that virtual hearings are very much possible. They're a means by which a hearing can be conducted. The other issue that we have encountered is situations where one party is very much in favor of a virtual hearing and the other is very much against the holding of a virtual hearing. And that is a situation where the tribunal is entrusted with some measure of discretion, but a discretion that needs to be weighed in consideration of all the aspects of the case. And that is something which, again, is highlighted in our ICC guidance note, and which we've seen tribunals apply very meticulously because of the potential repercussions in certain jurisdictions of holding a virtual hearing despite the objection of one of the parties. It is very much something which we are seeing. But it very much depends on the seat of the arbitration. It depends on the applicable law. It depends on the complexity and the sensitivity of a case. So I think all of those factors are being taken into consideration and should be measured in a decision as to whether to impose upon at least one party the organization of a hearing remotely.
Sebastian, allow me to jump in at this point because I'm having signals from Mercy in the room that our time is almost up, and I would actually like to use that last comment you made to ask one question. We're allowed one last question on this panel, and unfortunately, we will have to forego our Q&A session, but I would like to ask, so I think somebody's putting up a question on the screen. I do not know whether that is intended for me to read, but before I get to that one, I would like to ask actually James Kihara to comment on what, in your view, would be, or what would be your take on the reaction of Kenyan courts if a party brings a claim that an arbitral award should be annulled because that party did not have fair treatment by having been imposed a virtual hearing by the tribunal while it was opposing it. I know this is kind of maybe a very short way of putting it, and probably there's a lot of elements at stake, but I would like to have a sense of your view there, James, on how would be the reaction of the local courts facing such an issue.
Thank you very much. I don't have come across right now any issue that has been presented in court that a party is saying that they were not given they never got an opportunity of being heard. Because it was a virtual hearing. But what I have seen is the practice has been that litigants and advocates in particular have already embraced the virtual hearings. This is because on the command courts, virtual hearings is what is going on. So what the parties do is that during your preliminary meeting, it is agreed that you will have probably virtual proceedings and a virtual hearing or virtual proceedings and a physical hearing. That is what I have seen, but I have not seen a party, because you see, once a party in the proceedings has accepted that they are going to have virtual proceedings, then you can proceed with that. But if the party is against that, like for example, if you look at the guidelines at, for example, the Nairobi Center for International Arbitration, they have come up with even an agreement where parties would sign and say, yes, we agree to this virtual hearings. So to me, the parties ideally would have to agree to that, and that would avoid a challenge in the High Court, that a party never got the opportunity of presenting its case or to be heard. And of course, as we move along with this, I myself as an arbitrator, even though there is a lot of online communication in terms of emails, for example, I have insisted that parties ought to, once they receive an email, they need to confirm they have received that email, because sometimes you're moving on and somewhere have later on in the proceedings, somebody says, I never saw this email, I don't know about it, and I never saw it. So we have, it's a system we are creating, it's a practice we are creating, and I think with time, we are going to make this system perfect.
Thank you, James. Thank you very much, and thank you to all three of our panelists for this session. I guess we'll just have to wait and see if the issue is ever raised before the Kenyan court and what would be the reaction. It's been a pleasure to be with you today. I wish everyone an excellent day ahead.